Ooh. Hello, everyone. Jax West from Stephen Avery Project, Justice with Jax, and MAM Gossip. And there we go. My screen just totally went white, and it's like, oh no, did this screw up? But I'm guessing I'm still here. So I am going to you live. Today is February 10th, 2025, and it is currently 5:15 p.m. Chicago time. We get a lot of people who watch the videos after it's been live, and they ask questions as they're watching it, thinking I'm live at that time. So if you're watching this any other day and time after February 10th, 5:15 p.m., it's a recording, so I cannot answer your questions at that time. So you could always message Stephen Avery Project, or you can email us at officialstephenaveryproject at gmail.com. So I'm going to read today the filing that Kathleen Zellner did on Friday to the Wisconsin Supreme Court. Christopher, our moderator, if you're on here, if you could post the link for people to read for themselves. I think that got posted over the weekend. So, those of you who don't want to listen to me and want to read it on your own can do so. This was filed, as I said, on Friday. Kathleen does that a lot with filings that they get dropped on Friday near the end of the day. Um, I wasn't aware of it until somebody messaged me on Saturday night that it had been filed. And so this is the first I've been able to sit and go over it. I have not read this. I usually save it to read with y'all and hear it read it for the first time for myself as I'm reading it to you all. As I'm looking at my other screen to read this, if you post any questions, I might not see them because I am reading. So if you are somebody who is one of our longtime, why did my mouse quit working? Longtime supporters, and you know people's answer or know the answers for people, could you please answer them, since I won't necessarily be able to see it. This is going to be a pain if I cannot use my mouse on this and have to try and use on the laptop. So, as I said, this is 31 pages. We start on page 6. It's the very bottom of page 6 when stuff actually is important to read. And this section is titled Criteria for Granting Review. This case presents, quote, special and important reasons, unquote, justifying Supreme Court review. The Court of Appeals conceded that the Sawinski affidavit establishes, quote, a possible's italicized, connection between the third party and the crime, close quote. The court reached this conclusion improperly, but by improperly weighing this evidence and imposing an improper burden of proof on Mr. Avery to meet the standard for an evidentiary hearing. This misapplication of the law and misinterpretation of the facts has resulted in a constitutional violation of Mr. Avery's due process rights to present a complete defense at his trial. Issue 1. Misapplication of State versus Edmonds and Brady versus Maryland. The first issue concerns whether the Court of Appeals misapplied the standard for evaluating newly discovered evidence on post-conviction, which is governed by State versus Edmonds, by restricting Mr. Avery's new evidence to the establishment of potential third-party suspect evidence governed by State versus Denny in order to satisfy the materiality prongs of Edmonds and Brady, even though Mr. Avery offered numerous reasons why his newly discovered evidence is independently material without regard to the Denny third-party suspect standard. Issue 2. Misapplication of State versus Denny. Hold on a second. Oh my gosh. This laptop I only use when I go live, and so then it always wants to be stupid on me. Okay. The second issue concerns whether the Court of Appeals misapplied the standard for potential third-party suspect evidence set forth by State versus Denny by creating impossible standards for satisfying the motive, opportunity, and direct connection prongs of Denny in a post-conviction pleading, contrary to Wisconsin law. This court should grant review because the Court of Appeals decision is in conflict with this court's decision in State versus Denny. Issue 3. Misapplication of State versus Balliet. This issue concerns whether the Court of Appeals misapplied State versus Balliet in denying Mr. Avery an evidentiary hearing, and in doing so has deprived Mr. Avery the ability to raise a complete defense in violation of his constitutional rights. This case presents unique constitutional issues based on the Court of Appeals' misapplication of the law and misinterpretation of the facts to Mr. Avery's case and his newly discovered evidence. Next section is titled Statement of the Case. I hate when this side gets pop-ups that I then have to X off. Okay. Statement of the case. On March 18, 2007, Mr. Avery was convicted of first-degree intentional homicide and felon in possession of a firearm. Let me pause there. Oh, I can't even move my mouse over because my mouse isn't working. This is a thing that a lot of people do not realize. Stephen always would have been going to prison, even if he hadn't been set up for this, which I believe he was framed for this. But because he is technically a felon due to when he pointed the gun at his cousin and he chased her off the road. So he is now a felon, and that shotgun that was above his bed. Now, if you follow this case, you know that gun did not belong to Stephen Avery. That belonged to his landlord, Raleigh Johnson. For those of you who might be new to this case and don't know all of this information, that trailer that Stephen lived in was not owned by the Avery family. That little piece of the Avery land had been sold to Stephen's his dad, Alan Avery's friend, Raleigh Johnson, years ago. Because Raleigh, I always forget which way that's pronounced. But he wanted a place to park his hunting trailer. And so Alan sold that piece of the land to Raleigh. So that garage, that trailer, and almost everything inside that trailer belonged to Raleigh. When Stephen's girlfriend, Jody, rented that from Raleigh, everything in there was Raleigh's. She brought a bed and a desk. So the gun that was hanging above Stephen's bed is Raleigh's. Raleigh testified to it. Raleigh testified to shooting that gun all over the salvage yard. But due to him being a felon, he could not have a gun in his possession. Now, I believe Stephen was confused about this because the state of Wisconsin issued him a hunting license. So if he's not allowed to own a gun, why do you give him a hunting license? So, but anyway, I don't know how much time Stephen would have gotten. Maybe somebody else who's from Wisconsin or an attorney or something could chime in and tell us what that would be. But Stephen would have been doing time regardless because he's a felon in possession of a weapon. All right. Or a firearm, as it states here. All right. Back to page 8. He was found not guilty of mutilation of a corpse. He appealed. The Court of Appeals affirmed. In 2009, he filed a motion requesting a new trial. An evidentiary hearing on Mr. Avery's post-conviction motion was held. On January 25, 2010, his motion was denied, and he appealed. The Court of Appeals affirmed. Oh, shoot, I got to go back over here. In 2013, Mr. Avery filed a pro se motion requesting a new trial. I believe pro se, I'm trying to remember all this stuff. And now remember, I'm not somebody who pretends to be an attorney. So I am not the best one to give you legal stuff. But I think pro se means that Stephen filed it on his own behalf. I think. Filed a pro se motion requesting a new trial. It was denied. On June 7, 2017, Mr. Avery filed a second motion. And there's a footnote. And the footnote says, citations to the record on appeal appear with the document number before the colon and the... Oh, we don't need to read that. Doesn't matter. Who cares? I don't read a lot of the stuff in these motions, especially when it pertains to past cases, not Stephen's cases, but when they compare it to other cases, because I don't care. And if you care and want to read all that legal stuff, pull it up and read all that stuff for yourself. The petition was dismissed without an evidentiary hearing. On October 6, 2017, Mr. Avery filed a motion to vacate, and on October 23, 2017, he filed a motion for reconsideration. The Circuit Court denied his motions to vacate and for reconsideration. On October 11, 2019, Mr. Avery filed an appeal. Mr. Avery filed motions to stay and remand concerning 2 additional claims. Mr. Avery raised his claims in his motions to the Circuit Court as supplemental post-conviction motions. The Circuit Court denied his motions to supplement. On April 12, 2021, a new witness revealed exculpatory information impeaching Bobby Dassey by establishing that he put the victim's car on Mr. Avery's property. Mr. Avery filed a motion to the Court of Appeals to stay his appeal and remand to allow Mr. Avery to add a claim based on the new witness. On July 28, 2021, the Court of Appeals issued a per curiam, however you say that word, opinion, upholding the Circuit Court's summary denial of Mr. Avery's claims raised in his petition and 2 supplemental motions, holding that Mr. Avery's motions were insufficient on their face to entitle him to a hearing, but reserving his ability to refile his supplemental motion number 6. On August 16, 2022, Mr. Avery filed his third motion for post-conviction relief pursuant to whatever number. Mr. Avery filed an amended motion on December 6, 2022. Mr. Avery's motion set forth newly discovered evidence that a third party, Bobby Dassey, was seen in possession of the victim, Ms. Halbach's vehicle, after her disappearance. Mr. Thomas Sawinski contacted the New York Innocence Project about this matter in 2016. Although Sawinski originally believed it was Mr. Avery's trial defense attorneys that he contacted in 2016, After finding an email verification, he realized it was rather the New York Innocence Project he contacted, and thus he amended his original affidavit, which was submitted in Mr. Avery's motion to stay his appeal to the appellate court, and Sawinski's amended affidavit was filed to the circuit court reflecting this mistake. Affidavits from two other new witnesses in Mr. Avery's case, Mr. Kevin Romlo and Mr. Thomas Barash, corroborate Sawinski's observations. And the footnote on that page says, in Romlo's affidavits provided to the circuit court, Romlo described observing Ms. Halbach's RAV4 parked at the turnaround at State Highway 147 and the East Twin River Bridge on November 3rd and 4th, 2005. Romlo stated that he reported his observation to a Manitowoc sheriff's deputy he encountered on November 4, 2005 at the Senex station at State Highway 147 in Mishicot. In Barash's affidavit, he states that sometime before 2 a.m. on November 5, he was driving a tow truck in the area of Highway 147 and County Road Q in Manitowoc County and saw RAV4 driving south on County Road Q, turning left off of County Road Q as it passed him. He recognized Bobby as the driver. He did not recognize the passenger in the vehicle. He is 100% sure it was not Mr. Avery. And we have taken a lot of field trips to every place listed in this case. So you can go into our past videos here as well as on MAM Gossip, and that's where you'll find our videos from all of our trips over the years. All right, let me scroll back over to here. In Mr. Avery's motion, Mr. Avery also raised Brady claims relating to the information from the new witnesses. Mr. Avery attached affidavits and documents showing that after Sawinski contacted Mr. Avery's current post-conviction counsel and provided the newly discovered evidence, Mr. Avery's current post-conviction counsel, through its investigator, submitted its second public records request pursuant to the Freedom of Information Act, a FOIA, to the Manitowoc Sheriff's Office for audio recordings of incoming and outgoing phone calls and or radio dispatches between November 3, 2005 and November 9, 2005 relating to the case. The FOIA-produced audio recordings did not contain the Sawinski call, nor did they contain any dates or times of the calls produced. In May of 2022, Mr. Avery's current post-conviction counsel received the previously suppressed Sawinski call to the Manitowoc Sheriff's Office, which contained a partial recording of the Sawinski suppressed call to the Manitowoc Sheriff's Office on November 6. For the first time, current post-conviction counsel received the exact dates and times of the Manitowoc County Sheriff's Office incoming calls. As part of its investigation, Mr. Avery's investigator then interviewed Sawinski's ex-girlfriend, whom he was dating at the time of the November 5, 2005 incident. Sawinski's ex-girlfriend, Devin Novak, corroborated Sawinski's account of what he had witnessed and what he had relayed to law enforcement. Further, Ms. Novak recognized and identified Sawinski's voice on the recording, played to her by the investigator, of a phone call made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Mr. Avery's investigator interviewed Sawinski again and played the same audio recording of the phone call that was made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Sawinski identified his voice in the audio recording of the phone call from November 6, 2005. The recording of Sawinski's call was never disclosed by the state to Mr. Avery's trial defense counsel prior to or during the trial. Pre-trial, trial defense counsel made two specific requests for all exculpatory evidence and or information within the possession, knowledge, or control of the state, which would tend to negate the guilt of the defendant, or which would tend to affect the weight or credibility of the evidence used against the defendant, including any inconsistent statements. The failure to disclose the audio call to trial defense counsel was a clear-cut Brady violation. An additional Brady claim stems from the evidence from Romlo. Romlo described in his affidavit that he reported his observation of the RAV4 parked away from the Avery property to a Manitowoc Sheriff's deputy he encountered on November 4, 2005 at the Senex station on State Highway 147 in Mishicot. No law enforcement report was ever generated by this Manitowoc Sheriff's deputy memorializing the conversation between Romlo and this deputy about Romlo's observation of Ms. Halbach's vehicle. The Circuit Court denied Mr. Avery's motion for post-conviction relief on August 22, 2023. Mr. Avery filed a timely notice of appeal on August 24, 2023. On January 15, 2025, the Court of Appeals issued a per curiam, however you say that word again, decision, affirming the Circuit Court's denial of Mr. Avery's claims. Mr. Avery will accept the facts as stated in the Court of Appeals opinion on pages 2 through 8. Next section is titled Argument. Whether the appellate court improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of State v. Edmonds and Brady v. Maryland. Standard of review. The state's highest court will not disturb a circuit court's decision to admit or exclude evidence unless the circuit court erroneously exercised its discretion. A circuit court erroneously exercises its discretion if it applies an improper legal standard or makes a decision not reasonably supported by the facts of record. We are now on page 12 of 31, imposing improper standard on newly discovered evidence. Both the Circuit Court and Court of Appeals imposed an improper standard in evaluating Mr. Avery's newly discovered evidence. The Court of Appeals found, quote, the Circuit Court properly recognized Avery's newly discovered evidence was not independent from Avery's attempt to meet Denny and addressed whether the evidence was material within the confines of his third-party perpetrator argument, unquote. I just got a Google alert of an article on this filing. Where was I? Both lower courts improperly merged two standards into one in order to deny Mr. Avery's newly discovered evidence. The merging of the two different standards, that in Edmonds and that in Denny, allowed the lower courts to base the materiality of Mr. Avery's evidence of proving that Bobby had a sexual motive to kill Ms. Halbach, and also prove beyond a reasonable doubt that he alone, sorry, these glasses are not helping me read very well on the screen. Sexual motive to kill Ms. Halbach, and also prove beyond a reasonable doubt that he alone made every single pornographic search on the Dassey computer. I should say the Bobby Dassey computer. The lower court's analysis completely ignores... Oh, wait. Hold on. Now I got to scroll over here because I see my husband posted something and I can't see any of the comments. Oh, so people have been commenting and I didn't see. And my husband's commenting because the dogs keep barking. And the reason the dogs keep barking is because My husband comes home around this time, and so every noise they're hearing, they think it's him home, so they start barking for him. So it's your fault, Jeff, if you're still listening. Okay, back over to here. Where was I? Oh, the Bobby Dassey computer. The lower court's analysis completely ignores that the Sawinski evidence is independently material for numerous other reasons besides proving that there is a third-party suspect for the murder of Ms. Halbach. In Mr. Avery's third motion for post-conviction relief, Mr. Avery explained how his new evidence was independently material from demonstrating a Denny third-party suspect. Specifically, he argued, quote, the Sawinski evidence is material to several issues of Mr. Avery's case. It is material for establishing Mr. Avery's defense, that is, that a third party committed the crime against Ms. Halbach. Additionally, the Sawinski evidence is material to the evidence in the RAV4 being planted by Bobby, including Mr. Avery's blood and DNA. The RAV4 also contained the Halbach vehicle key and Ms. Halbach's electronic devices, which were discovered in Mr. Avery's bedroom and burn barrel, respectively. Further, the Sawinski evidence is material to impeach Bobby's trial testimony that Ms. Halbach never left the Avery property and that she was last seen walking towards Mr. Avery's trailer, unquote. The Court of Appeals avoided addressing this independently material evidence by inaccurately claiming, quote, Avery only analyzed the Sawinski evidence within the context of a third-party perpetrator defense, unquote. Oh, hello, Christopher. The Court of Appeals pointed out in paragraph 4 of its opinion from July 28, 2021, quote, the state's theory was that Avery shot Halbach in the head in his garage and threw her in the cargo area of the RAV4. He then burned the electronics and camera, cremated Halbach in a burn pit, transferred the remains to a burn barrel, and hid the RAV4 until he could crush it in the Avery car crusher, unquote. Mr. Avery argued that Sawinski's new evidence is material because it shows that the RAV4 did leave the Avery property and was in possession of a third party, not Mr. Avery. There's my husband pulling in right now, so the dogs will start barking again. The RAV4 did leave the Avery property and was in possession of a third party, not Mr. Avery, thereby debunking the state's theory that Mr. Avery had, and now this is italicized, exclusive possession of the vehicle and the forensic evidence contained therein, and that he kept the RAV4 on the Avery property by the crusher so he could crush it immediately. The prosecutor, in his closing argument, told the jury that only one person was responsible for the crime, and that was Mr. Avery. Let me scroll to where I need to start reading, but first I want to say this. Oh, and hello, Jocelyn, and hello, Corey. The car crusher. All right. So that car crusher was not owned by the Averys. They borrowed that from another salvage yard. And if it was there at this time that Stephen has to wait to use this car crusher when nobody's around, then why did he go with the family to what's the name of that town that I'm now blanking on it? Somebody help me. On where they have their vacation homes, where Alan Avery, Crivets. Is it Crivets? So Stephen and Brendan went that weekend, the weekend following when Teresa Halbach had been there on Halloween. So that first weekend in November, they went. Thank you, Chad, for messaging and saying Crivets. It is Crivets. See, I know so much about this case, and I've forgotten so much of it, and it's hard to remember that stuff, and I'm old. Um, so Stephen and Brendan went to Crivets. Bobby didn't go to Crivets. So if Stephen needed the opportunity when the family's not around to crush this car, why would he go? So that makes no sense at all. He had a car crusher. Family was leaving. He could have done that. Also, there is a whole gravel pit and quarry all behind him. I've driven through there before. There are big, huge trees that you could literally drive a car underneath these big evergreen trees and nobody would see it. You wouldn't see it from a plane. You wouldn't see it driving through there. So why would Stephen park it at his own salvage yard? And for us, the salvage yard, it's a junkyard. There's no rhyme or reason to all these vehicles. But to the people who run that salvage yard, they have all these kinds of cars are here and these kinds of cars are here. So this RAV4 was parked in a place that RAV4 would not be. And it was double parked and facing a different direction. And then, yeah, it has this stuff put on top of it to make this vehicle stick out even more. And then also where this little road was, at the very back of the salvage yard, there is a little pond right in front of it, as well as trees. Stephen could have driven that car into the pond, and that pond is deep enough that it would have sunk, and that also then would not be seen from a plane or from anybody. So while Stephen has a low IQ, that doesn't mean he's a complete imbecile and wouldn't know to put the car someplace that's not going to be traced back to him. So why would he leave it right there to wait for people to leave? But then he would also leave. And there's allegedly all this stuff that's burning and her electronics and all this stuff. So wouldn't he go? Because this trip that the family took to Crivets that weekend was planned in advance. Stephen was going there to help fix a roof. So he knows the family's all going. So he could have just said something suddenly come up and he's got to stay home. And he could have gotten rid of all this stuff. But he didn't. He left. Makes zero sense. I'm sorry. Stephen's not that dumb. All right. Back to page 13 of 31. As Mr. Avery argued, the evidence of a third party's possession of Ms. Halbach's vehicle is additionally material because it shows that someone other than Mr. Avery had possession of the forensic evidence used to convict Mr. Avery. The vehicle, by virtue of having all of the relevant forensic evidence in it, including Ms. Halbach's blood, was the most important piece of evidence in the case. In his closing, the prosecutor stated, quote, because the discovery of the RAV4, the discovery of Teresa Halbach's vehicle changed the course of not only this case, but the clues and secrets found in that vehicle changed the lives of everybody in this room, unquote. Blah. The prosecutor emphasized to the jury that, quote, nobody had access to the car, unquote, and, quote, no one was going to tamper with the SUV after it was located, unquote. However, the Sawinski evidence establishes that Bobby, the state's primary eyewitness, had access to and the ability to tamper with the vehicle before it was located. Mr. Avery was entitled to have presented this critical fact to a jury, and not being allowed to do so deprived him of his constitutional right to present a complete defense. All right, let me scroll this because I'm going to go off again, off script. If you care about justice and the law, Why is our system set up so it is so difficult to get back into court when there is new evidence or evidence that the prior hearing was screwed up and flawed? Why is it okay that the state of Wisconsin has the RAV4? It was agreed to give Kathleen Zellner the ability to run her own tests on that RAV4. Why is that RAV4 gone? And why can't Stephen's attorney do tests on it? We all know that our science has jumped leaps and bounds since this case in 2006. The Innocence Project is all about DNA. They rarely will take a case unless there's DNA to help free the wrongfully convicted. So why is it okay for the state to hide the RAV4? And these are the people who claim that they care about Teresa Halbach. You can't possibly care about Teresa Halbach or want justice for Teresa if you are going to hide evidence. I don't get it. And these witnesses, I don't understand how a judge can declare, oh, if the jury knew about these witnesses back during the original trial, they still would say guilty. You don't know that. You can't know that. Only the jury would know that. Plug for again, if you were on Stephen or Brendan's jury, I would love to talk to you. It could even be off the record. You can reach out to me by messaging this page, or you can email official Stephen Avery Project at gmail.com or justicewithjax at gmail.com. But I would also advise you, please, if you're a juror, reach out to Kathleen Zellner and talk to her. I want justice for Teresa Halbach. Stephen, I have no loyalty to Stephen Avery. I am not a part of this case because I am related to Stephen in any way. Stephen Avery actually doesn't like me. And yet here I am. I am one of the few people who started on this after Making a Murderer came out in December of 2015, that will still publicly declare that Stephen is innocent, and am still here all these years later. And as Christopher posted a link to my book that's on Amazon, Wrongfully Abused, you can read why Stephen Avery doesn't like me, and my history with Stephen Avery, who I have visited a couple of times. Here's two different pictures from visits with Stephen. Stephen doesn't like me. Read my book and find out why. So I have put up with a lot of abuse over the years. Still to this day, people try to do things to me due to my support of Stephen's innocence. So if there was any proof that Stephen was guilty, I would tell you, oh my God, I was wrong. And here's why. Here's this proof. But everything that comes out proves Stephen is innocent. And I want Stephen to go home. It's a travesty that he's been in there, that he served 18 years previously for the Penny Bernstein case that he didn't do. And now he's been in prison, or I should say incarcerated, since 2005. this is crazy. And in this time, his mother died. So his mother will never see him go free. His father gets older and older every day. Health isn't great. He could lose his father. Stephen should go free. And if there was any evidence to say he was guilty, I would tell you Stephen is innocent. And I don't understand why it is so hard to at least have an evidentiary hearing. Judges, judges have egos, whatever. Nobody wants to say they were wrong. And I don't see any shame in admitting you're wrong. If you were given on evidence to the contrary of something that you firmly believe, to go, oh my God, that changes everything. That person is guilty or that person is innocent. And so these judges who are supposed to be about justice, it shouldn't be this hard to get back into court. And I do not think, since these judges have these egos, that anything should go back to a same judge that has ruled against you. Obviously, they can't be impartial. Sorry, a little rant there. Back to what we were reading. Despite police searches preceding the discovery of Ms. Halbach's vehicle, Ms. Halbach's electronic devices and key were not found until after Ms. Halbach's vehicle was found. The only reasonable inference is that all the items remained in Ms. Halbach's vehicle and were then moved by the third party who had possession of her vehicle and planted it in and around Mr. Avery's residence. Okay, I gotta scroll this down because I'm gonna go off again, off script. Okay, so a thing that I differ on from Kathleen Zellner, that there has been no proof to prove to me that Bobby Dassey is who planted Stephen's blood in the RAV4. I am not saying that Bobby's not smart enough to do that. Many of the Avery family have low IQs. Stephen's IQ is actually lower than Brendan's. But Bobby Dassey does not have the low IQ. But I do not believe he planted the blood. I still believe the police planted that blood. And I believe they got access to the RAV4 and the key from Ryan Hilgas. Or Ryan Hill, as he is on Facebook now. Because that key that was found in Stephen's bedroom is her valet key. It is not the key that she used every day. And if you go through trial transcripts, you will see not one, but two people from Teresa's life testified, or no, three people testified that Teresa was extremely paranoid about losing her keys. That's why she had this long lanyard that her one of her little sisters had gotten her that lanyard. But her friend testified that they had gone camping was it August? They had gone camping, and she jokingly made this long lanyard for the keys out of tape. Her boss at the photography studio testified about her being afraid to lose her keys. So, and then her little sister testified about the lanyard. So, somebody who is so afraid to lose their keys, then why would they be carrying around one key by itself, which is again only the valet key and not the key with your what's it called? Here I go, forgetting words again. I don't know if my husband's watching this downstairs. The thing to click to unlock your car and all that stuff, whatever that thing's called. Why didn't she have that? Where's her house key? Where's her key to the photography studio? This would all be on one key ring. There wouldn't just be the valet key. And then why does her key that she's using regularly, this key is going in and out of her hand constantly because she takes these photos, and so she's driving her car a lot. None of her DNA is on that key, but Stephen's DNA is on that key. So what that says to me is either this is a key that's she didn't really use, or B, or both. Could be both, but both A and B. Or B, somebody cleaned it and then planted keyless entry and remote. A fob! Key fob. Thank you again, Chad. So they cleaned off Stephen, or they cleaned the key and then had to put Stephen on there. So this whole key thing makes no sense to me. So I believe that Ryan Hilgas, Scott Blodorn, and Mike Halbach, right? I believe police, or I shouldn't say police. I'm sorry, you have to keep straight between the police and the sheriff's department, because the Manitowoc Police Department weren't involved in this and did nothing against Stephen. It's all the Manitowoc County Sheriff's Department. But I believe that in talking with these three guys, it was Steven Avery did this. We know he did this. He's got this case against us, and he's gonna walk. And so they then gave him the valet key, gave the sheriff's department the valet key, and that's how they were able to access it. And then that's also how Ryan Hilgas had her planner. That when you look at her day planner, remember, this is before cell phones were as big a deal as they are now. And so Teresa Halbach used a written day planner, and things that were written on that day planner are things that happened that day. Yet Ryan Hilgas had access to it. So I believe they got her valet key from her house that she was sharing with Scott Blodorn. Scott Blodorn was a good friend of Ryan Hilgas, who was now living with Teresa and was a friend with benefits for Teresa was having sex with Scott Blodorn. So I believe the police got the key from them, and that's how the key then makes it into Stephen's bedroom. And I am not a tinfoil hat conspiracy theorist. I know this stuff sounds crazy, but this is what all makes the most sense to me. And at the time, if I were those three guys, I might have done the same thing. If I believe my loved one's been murdered by this guy, and I have no reason to believe that this law enforcement are shady or anything like that, I would believe what cops are saying to me, right? And oh my God, I don't want this guy to walk. So here's this stuff. I'll give you, you're going to give this stuff. But in the years since then, since Making a Murderer came out, you got to question this evidence. So I'll again say, if any of those guys watch this, please reach out to Kathleen Zellner. Go to her website, KathleenTZellner.com. She's got a Stephen Avery page. There's my sexy girlfriend, Miley. She's got a phone number and an email that is just for the Stephen Avery case. Please reach out to Kathleen and get justice for Teresa Halbach. All right, I think I've gone enough into the weeds on there. Let me go back to reading this. If a third party had possession of Ms. Halbach's vehicle, numerous areas of reasonable doubt arise, such as that the forensic evidence in the vehicle was tampered with by the third party having control of it before is italicized, before it was discovered by law enforcement on the Avery property. Pause. Miley, I'm so happy hearing all the good stuff about Costco in the news. Okay, back. This would have created reasonable doubt in the jurors' minds, particularly since the state's primary eyewitness witness was the one in possession of the vehicle. Thus, Mr. Avery's new evidence also presents an alternative theory for the source of the forensic evidence used against Mr. Avery. Importantly, Mr. Avery also argued that the Sawinski evidence impeaches the credibility of Bobby's trial testimony, where he established an alibi for himself while implicating Mr. Avery in the murder. In fact, Mr. Avery spent numerous pages on his third motion explaining the impeachment value of Mr. Avery's new evidence. Let me scroll because I'm going to go off script again. Sawinski came forward in 2005 when this case originally happened. He called the Manitowoc Sheriff's Department to tell them what he saw. And they, I'm going to swear, earmuffs, they fucking buried it. And so Sawinski thought by calling the Manitowoc Sheriff's Department that he had done his due diligence. And they never reached out to him to follow up. And he just figured, okay, they, had my evidence and didn't, or my report, whatever you want to say, and they don't need anything else from me. And then it isn't until years later when he watches Making a Murderer that he sees, holy shit, nobody's talking about what I saw. So he decided to reach out to who he thought was Stephen's attorneys. And it was the Innocence Project. The Innocence Project, well, yes, I know the Innocence Project does a lot of good things. So I don't want to just full on attack the Innocence Project, but they did dump Stephen. Lots of people instantly dumped Stephen as soon as this case happened, who should have known better to at least do some investigating and not just believe automatically when you see it's the same cast of characters that were involved in the Penny Bernstein case. Even Penny Bernstein turned on him immediately. And I've got no sympathy for her on that. I find that absolutely disgusting. Yeah, she was tricked and manipulated into saying Stephen did that to her. But to immediately jump on Stephen's guilty of this, hello, Billy, I'm disgusted. Disgusted. But this guy Sawinski came forward in 2005. Then, when he watched Making a Murderer, he didn't watch it immediately when it came out in December of 2015. But when he did watch it, he reached out to who he thought was his attorneys. Innocence Project didn't reach out to anybody to pass that on. So then when he learns that that's not Stephen's attorney years after that, then he reaches out to Kathleen Zellner. So This is new evidence, even though it's not new evidence. But it was never heard in court that he saw Bobby Dassey pushing the RAV4 with somebody else towards the salvage yard. I'm just aghast at a judge saying that a jury would say, that doesn't matter. Bobby Dassey is the star witness who is the last person to see her alive. And how true is that? Because actually, if Stephen were guilty, wouldn't he be the last person to see her alive? No, Bobby Dassey is. Why is that? Because Bobby is the one who did whatever happened to her. We don't know if she was raped. We don't know if she was shot. We don't know what happened to her. But Bobby admits to seeing her that day. And Bobby claims when he left to go hunting, when he and Scott Taddock did the crisscross, we see each other at this exact time. We're both going hunting 2 different ways. Bobby's going to hunt at Scott's house, but Scott's going to hunt down this way. Bobby said the RAV4 was gone. It wasn't there anymore. But there was a witness that saw him pushing the RAV4 back to the salvage yard on what date was that? November 4th? That he's saying somebody, here come Chad. Where are you, Chad? Was it November 4th that he said that he saw it? And was November 4th when Stephen and Brendan are in Crivets? Somebody refresh my memory. It's so hinky. Ugh. Okay, back to reading. Bobby testified that he left the property while Ms. Halbach and her vehicle remained on the property with Mr. Avery. This crucial testimony allowed the state to claim Chad the early AM of the 5th. I love you, Chad. Thank you very much. Where was I over here? This crucial testimony allowed the state to claim it was Mr. Avery, not Bobby, who murdered Ms. Halbach and concealed her vehicle on the property. During its closing argument, the state emphasized the importance of Bobby's testimony, vouching for his credibility. Quote, again, an eyewitness without any bias. It is and this is intentionally spelled wrong, that it should be an individual, but it's a individual that deserves to be given a lot of credit, unquote. With the new Sawinski evidence, the state could not possibly have presented an unimpeached Bobby to establish Ms. Halbach never left the property in her vehicle and that she was last seen walking towards Mr. Avery's trailer. Its critical eyewitness link to obtaining Mr. Avery's conviction. Bobby was the only witness whose testimony the jury requested to, quote, read or hear a transcript of, unquote. Wait, let me scroll because I'm going to go on a rant. If you're new or could have forgotten or never known, Stephen was never going to be found not guilty. His jury had not one, but 2 people affiliated with the Manitowoc County Sheriff's Department. One person was married to somebody at the Sheriff's Department, and another person was the father of a deputy. And this man was also, I am so forgetting a lot, community service officer for the Manitowoc County Sheriff's Department. You can Google, what is his name? I want to say Carl Wardman is his name. So you could Google Carl Wardman, Manitowoc Sheriff's Department. You will see a picture of him with a community service vehicle. Both the driver's door and the passenger door are open, much like how Sawinski saw Bobby walking with the car with somebody. Both of those doors were open as they pushed the car. Um, so you'll see Carl Wardman. Um, and if you look on Kathleen Zellner's website, on Stephen's page, or you just Google pictures of Stephen, you will see a picture of Stephen in the orange jumpsuit being cuffed, his hands in front of him. You'll see a male deputy on one side of him and a female deputy on the other side of him. And if you zoom in and look at the male's name tag, you will see his name is Wardman. So there was not one, but two people affiliated with Manitowoc County Sheriff's Department that never would have voted not guilty for Stephen. So at best, he could have gotten a hung jury. But we know that Carl Wardman was kind of a dick in that jury room and bullied people as well. Okay, let's get back to reading. Christopher, was that the one? Because it was a different last name. So, oh gosh. Okay. Let me go back. Sorry. Clearly, by Bobby possessing the vehicle, there is a reasonable likelihood it would have affected the judgment of the jury in that Bobby would have emerged as a much more likely suspect in Ms. Halbach's murder than his recently released, wrongfully convicted uncle. Contrary to the state's representations to the jury, Bobby was biased and deserved no credit for his fabricated testimony. We are moving on to page 15 of 31. See, we're only halfway there, but I haven't looked at the end of this, but usually the last few pages too are nothing we read. In regard to a motion for a new trial, a reasonable doubt as to a defendant's guilt has been found to exist when the credibility of a witness critical to the state's case is completely called into question by newly discovered evidence. Okay, now they're talking about other cases, and I'm not reading that stuff. And that's talking about another case, and I'm not reading that. Okay, let's get to where it's actually about Stephen. Mr. Avery presents a stronger case about the materiality of his newly discovered evidence because his evidence shows that Bobby committed perjury in his trial testimony, and it taints all of the forensic evidence used against Mr. Avery, which resulted in his conviction. Prior to the Sawinski evidence coming to light, the Court of Appeals assessed Bobby's testimony as follows, quote, certainly the testimony bolstered the state's theory that Halbach visited Avery on that day and did not leave the Avery property thereafter, but absent this testimony, the state still possessed significant forensic and other evidence implicating Avery in a crime committed on his property, unquote. However, in Mr. Avery's third motion, he brought forth newly discovered evidence that does both. It completely impeaches Bobby's testimony while casting doubt on all the forensic evidence used against Mr. Avery. Thus, Mr. Avery has shown how his evidence is highly material independent of establishing Bobby as a third-party suspect. Besides requiring Edmund's materiality to be solely based on being able to meet the Denny requirements. Hi, Elizabeth. The Court of Appeals erroneously found, quote, Avery did not offer any analysis that explained why his newly discovered evidence was not cumulative outside of his third-party perpetrator defense, unquote. However, even if there were multiple examples of Bobby's impeachment for purposes of a Brady claim, the court is not to view each piece of suppressed evidence in isolation. Instead, the court is required to assess the cumulative impact of all the suppressed evidence to determine its materiality. The continual effort to move the goalposts to thwart Mr. Avery's post conviction efforts by employing the use of a per curiam opinions, which blatantly violate his constitutional right to present a complete defense, cannot and should not be condoned. Further, contrary to the Court of Appeals' assertion that, quote, Avery did not offer any analysis that explained why his newly discovered evidence created a reasonable probability of a different outcome on retrial that was independent from Avery's attempt to meet Denny is in italics and bold, and addressed whether the evidence was material within the confines of his third-party perpetrator argument, unquote. Mr. Avery's third motion and briefs on appeal thoroughly analyze why the Sawinski evidence is independently material and would have created a probability of a different outcome on retrial. Next section's titled, Mr. Avery has not waived his Brady and interest of justice claims set forth in his petition. In Mr. Avery's third motion, Mr. Avery raised Brady claims relating to the information from the new witnesses and raised an interest of justice argument. As for his first Brady claim concerning the suppression of the Sawinski evidence, Mr. Avery attached affidavits and documents showing that after Sawinski contacted Mr. Avery's current post-conviction counsel, initially obtained FOIA-produced audio recordings which did not contain the Sawinski call, nor did they contain any dates or times of the calls produced. Then, in May of 2022, Mr. Avery's current post-conviction counsel received a partial recording of the suppressed Sawinski call to the Manitowoc Sheriff's Office on November 6. Sawinski's ex-girlfriend, Devin Novak, recognized and identified, this is the stuff over again, Sawinski's voice on the recording of Sawinski's phone call made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Mr. Avery's investigator interviewed Sawinski again and played the same audio. Didn't we read all this stuff? Isn't this the same thing? The recording of Sawinski's call was never disclosed by the state to Mr. Avery's trial defense counsel prior to or during the trial. If the call had been disclosed, Mr. Avery's trial defense could have traced the call to Sawinski by subpoenaing the phone numbers. Mr. Avery sufficiently pled his Brady claim concerning the Sawinski evidence in his motion for post-conviction relief, and this was not the issue disputed by the Circuit Court in denying his claim. The Circuit Court did not make any finding that Mr. Avery did not sufficiently plead his Brady claim. Rather, it disputed Mr. Avery's argument regarding the materiality of the evidence. In regard to the Brady claims stemming from the evidence provided by Romlo, he described in his affidavit that he reported his observation of seeing the RAV4 to a Manitowoc sheriff's deputy he encountered on November 4, 2005 at the Senex station on State Highway 147 in Mishicot. No law enforcement report was ever generated by this Manitowoc sheriff's deputy. You know who that deputy is, right? Memorializing the conversation between Romlo and this deputy about Romlo's observation of Ms. Halbach's vehicle. Again, Mr. Avery sufficiently pled his argument in his motion for post-conviction relief. The Circuit Court did not find otherwise, but rather it disputed the materiality of this evidence. The appellate court completely overlooked the Romlo evidence. Mr. Avery properly pled his interest of justice claim in his motion. However, applying the same rationale for denying his Brady claims, the Circuit Court found that, quote, the the defendant asks that the court grant him a new trial in the interests of justice pursuant to Wisconsin statute, whatever the number. Given the above conclusions reached with respect to the evidence offered by the defendant, there are no legal grounds to grant such a request, unquote. The Court of Appeals ignored Mr. Avery's actual pleading and circuit court's rationale for denying Mr. Avery an evidentiary hearing and improperly found that Mr. Avery's Brady and interest of justice claims were waived on appeal because it claimed that Mr. Avery did not argue that the Brady and interest of justice claims were sufficiently pled. However, this ignores the fact that the circuit court never found that Mr. Avery's claims were insufficiently pled. Rather, the circuit court accepted that they were properly pled, but concluded that Mr. Avery's evidence that was suppressed was not material, and for the same reason denied his interest of justice claim. Following the circuit court's rationale for denying his claims, Mr. Avery properly raised the issue to the circuit court's misapplication of Brady to his newly discovered evidence on appeal. Mr. Avery argued on appeal that the circuit court misapplied the law and required Mr. Avery to also prove Denny in order to satisfy the materiality prong for satisfying Brady. Christopher, did you post a link to so people can read this for themselves in this? I don't know if you did or not. I just thought of it. Mr. Avery argued on appeal that the circuit court misapplied the law and required Mr. Avery to also prove Denny in order to satisfy the materiality prong for satisfying Brady. Did I read that already? Sorry, squirrel. In Mr. Avery's brief, Mr. Avery pointed out that in evaluating Mr. Avery's Brady claim, the circuit court did not dispute that the prosecution had suppressed the audio recording of Mr. Sawinski's call, but that rather it disputed the materiality and favorability of the evidence. Mr. Avery argued that the circuit court's manner in determining Mr. Avery's evidence was not material was improper because, as argued multiple times, the evidence is material for reasons outside of Denny, including for its impeachment value. Mr. Avery could not have waived his Brady claims because they are within his argument that the circuit court improperly imposed a burden for him to also satisfy the Denny requirements in order to show that his evidence is material for bringing his constitutional claims, which obviously encompasses his multiple Brady violation claims. We're now on page 19. Because Mr. Avery has not waived his Brady claims and argued on appeal that the circuit court improperly held him to an improper standard for evaluating materiality, and the Court of Appeals improperly dismissed his claims as being waived, this court's review is required to adequately resolve the issue. Additionally, because the Court of Appeals affirmed the circuit court's misapplication of the law in evaluating Mr. Avery's newly discovered evidence and Brady claims, this court's review is required. Amanda, no, this is Kathleen Zellner they were denied on the lower court, and so this is a filing she did with the Wisconsin Supreme Court. So it talks about the denials of the lower court in showing that the lower court was wrong on their denial and that the Wisconsin Supreme Court should now handle this. I also wanted to say Denny always pisses me off too, in that you do not have to prove that Stephen has a motive. But Stephen, in bringing up any possible other person, has to prove their motive. I call bullshit on that. I don't like that. And Amanda's asking, so will it ever get overturned? It is very hard to overturn a wrongful conviction. Kathleen says it typically takes her, because Kathleen Zellner is the person who has overturned the most wrongful convictions, that it typically takes 18 years since she takes the case to overturn a wrongful conviction. And she took Stephen's case January of 2016. So even though Stephen has been incarcerated since 2005, the clock only starts for the 18 years in 2016. Yeah, holy shit is right, Amanda. So, should it get overturned? It should. Uh, it's really hard to get it overturned, and it is even harder for Brendan because Brendan confessed. Stephen has always said he was innocent, so Stephen has a better chance than Brendan. All right, the next section is called Whether the Court of Appeals erred when it did not correctly apply State versus Denny to Mr. Avery's potential third-party suspect evidence. Yeah, Amanda, it is so messy. Standard of review. The appellate court generally reviews a trial court's decision to admit or exclude evidence under an erroneous exercise of discretion standard. However, when a defendant's constitutional right to present a defense is implicated by the exclusion of evidence, the decision not to admit the evidence presents a question of constitutional fact that the appellate court reviews de novo. De novo is... It's de novo when you only have like 3 of the judges panel, or is that when you call for all of them? I can't remember now. Somebody update me on that. Hello, Flo in London. Amanda, the chances are not good that Brendan is going to get out. All that Brendan is really left with is the governor letting him go. And the governor has said that he won't. And let me state here, this is one of the things we have to say over and over and over again. And please, nobody talk politics in this chat. And I don't want politics discussed at all. I actually work in politics. I am a chief of staff for a state representative, so I can argue politics. This is not political. When I say, no matter who the president is, we had President Biden, who was a Democrat. Now we have President Trump, who's a Republican. It doesn't matter, Trump or Biden. Neither one of them can do anything for Stephen or Brendan. They can only pardon people on a federal case. Stephen and Brendan's cases are not on a federal level. They are a state case. So therefore, only a governor can do something on their case. We get people every day who message us, who post comments on current articles, old articles, then people who want to fight Republican versus Democrat. This president can do it. This president can, blah, blah, blah. No president in the United States can do anything for Brendan or Stephen. Okay. Let me go back to where I was reading. Okay. Oops, I'm trying to use my mouse. That won't work. Mr. Avery provided sufficient facts to meet the Denny requirements in his third motion. In Wisconsin, Denny governs the admissibility of potential third-party perpetrator evidence. Denny requires a showing that, quote, there must be a legitimate tendency that the third person could have committed the crime, unquote. A legitimate tendency is demonstrated where the defendant can establish 1, motive, 2, opportunity to commit the charged crime, and 3, provide, quote, some evidence to directly connect a third person to the crime charged, which is not remote in time, place, or circumstances, end quote. In deciding Mr. Avery's previous appeal of his second motion for post-conviction relief, the Court of Appeals specifically instructed Mr. Avery about the following, quote, "As discussed below, we are not addressing Avery's most recent filing to this is italicized, this court. See our discussion of motion number 6, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new motion. That motion would need to survive both Escalona Naranjo, which is another case, scrutiny and be found to have merit, in which case, now this next part is underlined, the evidence presented might supply the missing direct connection, and underlined. In that event, the Valley CD might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny is italicized and bolded, suspect. We express no opinion on the merit of any such motion as, why won't you scroll down now? As all such issues would be for the circuit court to decide if in the first instance, unquote. Seemingly having forgotten that it previously found that, quote, the Valley CD might become relevant to showing Dassey's motive, unquote, if Mr. Avery's third motion showed, quote, the missing direct connection, unquote, the Court of Appeals decided to adopt the circuit court's convoluted and faulty analysis of what is required to satisfy the Denny tests. Both lower courts improperly elevated the motive prong to the most important of the three prongs and imposed an impossible burden to meet in requiring each element, motive, opportunity, and direct connection, to be conclusively satisfied. Next section is titled, Mr. Avery pled sufficient facts to establish that Bobby had a motive is underlined, for the murder. In Mr. Avery's third motion, he alleged that the motive attributed to Bobby for Ms. Halbach's murder could have been sexual and provided evidence supporting this, namely the suppressed evidence from a computer that was in Bobby's bedroom. Further, Mr. Avery supplied evidence showing that Bobby was the primary user of this computer, according to his brother Blaine, whose affidavit Mr. Avery attached. Mr. Avery also showed that Bobby lied to police about the location of the computer, claiming it was in the living room, but crime scene footage showed it was in his bedroom. Liar. Mr. Avery supplied this additional evidence in the circuit court in his third motion, even after the Court of Appeals had previously acknowledged the potential materiality of the Valley CD in proving a third-party suspect. Let me scroll so I can go off script right here. Something that you can read about in my book. But I will tell you here something that Stephen told me. I have things that Stephen has told me that I have never seen anybody else talk to or talk about. And Stephen told me, now remember, Teresa Halbach went to the salvage yard multiple times before that Halloween of 2005. All right. So Stephen had her come a couple different times. I don't remember the number. It's probably in my book how many times she had been there previously. But Stephen told me that Bobby always knew when Teresa Halbach was coming. And after she would leave, he would always comment about Teresa Halbach to Stephen. And now Bobby especially knew that Teresa Halbach was coming that day to take pictures of his mom's van. And Bobby and the other Dassey boys were pissed about it, that their mom was selling this van. They wanted this van to be something that they could drive. And Barb told the boys she wanted them to clean up the van before Teresa Halbach, now she didn't say Teresa Halbach, but before the photographer came to take pictures of it. So Bobby knew in advance Teresa Halbach was going to be there. He absolutely knew she was going to be there. And Stephen told me that Bobby would comment on Teresa Halbach to him after the other time she had been there. So this guy had some kind of obsession with Teresa Halbach. So I personally believe, and this is just, there's no proof to any of this, but I think he got her to pull over under the guise of what is called a hustle shot. Teresa Halbach, working for Auto Trader magazine, for every job they sent her on to take a picture of a vehicle, she would be paid $10. If she brought a customer to Auto Trader, she would get $20. That is called a hustle shot. And so something Teresa would do, another thing of her driving around a whole bunch, is she would drive around. And if you would see a car with a for sale sign on it, she would approach them and ask them about selling the car, like she did the Zipperers that day. Hustle shot. So she gets double the money. So Bobby, wanting her to pull over to, hey, I want you to take pictures of this car for a hustle shot. Great, that's 20 bucks in her pocket that she wasn't going to get. And then I personally think he either hit on her to like ask her out or something, and she turned him down, or he just outright did something to her to which she's never seen again. So this whole Bobby Dassey computer thing, one, they're lying about where the computer was. They keep trying to push that it's the Dassey family computer when it was in Bobby's bedroom. Then these things of different porn and whatever was on them are only accessed with, you know, Bobby works nights. Everybody else is at school or work during the day. So Bobby is the only one that has access to the computer. When some of the family, like Barb, hi Barb, or not Barb, Carla, but hi Barb and Carla, because they always watch what I do. So when they like to say, oh, Stephen would have access to that computer during the day. Stephen had his own computer and had his own internet. If Stephen wanted to look at porn during the day, he would go do it on his own computer. Okay, Christopher. Why would, if Stephen wanted to look at porn during the middle of the day when his girlfriend is in jail because she's a drunk, why wouldn't he do it in his own home? Why would he go to Barb's home that he knows that Bobby would be home allegedly sleeping since he works nights? Why would he go in there to go look at porn? He would do it at his own place. So, and then why did they look at Stephen's computer trying to find porn, which they didn't find, to try and prove Stephen's motive, but to now see that Bobby, who's the last person to see Teresa alive, has porn on his computer? Why is that not a motive? Let me read what Matt's saying. Hypothetically, say Stephen gets a new trial based on this and is found not guilty. Based on the new third-party evidence, what does that mean for Brendan's conviction being overturned? Sadly, Matt, big question. Don't get it. Brendan and Stephen were prosecuted by the same guy, Mr. Sweaty Sweat. What's that douchebag's name? Oh my God, I am blanking on so much stuff today. Kretz. Sweaty Sweat prosecuted both of them. It's two completely different theories on what happened to Teresa Halbach. Matt, a lot of people forget this or don't realize this, but there's no Brendan in Stephen's case. So in Stephen's case, Stephen did it, and Stephen did it alone. So thank you, Matt. So in getting Stephen out doesn't mean Brendan would be overturned, because also Brendan confessed. And there are people who believe Stephen or Brendan is covering for another family member, that Brendan was still involved and he just said Stephen instead of Bobby. Now, I heard a noise. Sorry. I do not believe for 1 second that Brendan Dassey had anything to do with this. This is a sweet boy who can't harm anything. Okay? So Brendan is not covering for anybody. So this whole lie that Brendan's cousin Kayla came up with of saying that Brendan lost all this weight because he was upset, and they tried to use against Brendan saying that he lost this weight due to his feelings of guilt about this crime, when really any weight that Brendan lost is because he was upset about a girl breaking up with him. But anyway, Brendan would not be able to live with this. And you would see it just like you see when you watch his interrogation. And as soon as those, I'm going to swear again, so earmuffs, as soon as those fuckers are out of the interrogation room and his mom goes in there, Brendan instantly retracts. They got to my head. Brendan isn't hurting that girl. Never, ever, ever. But sadly, Ken Kratz, Mr. Sweaty Sweat, really screwed over Brendan. And Brendan's family, who are covering for Bobby Dassey and Scott Todek, are screwing over Brendan Dassey. Brendan has great attorneys. Stephen Drizzen and Laura Nyrider, right? That's her name. Oh my God, am I blanking on everything today? Laura was also involved in the West Memphis 3 case. Laura feels something special for Brendan, not in a weird way, guilters who are watching this. So Laura will never leave Brendan and stop trying, but things are way harder to get Brendan released than it is Stephen. All right, back to reading. Oh my God, how long have I been on here? An hour and a half already. Sorry, people. I know it. Sometimes I can really go on forever. All right, so back to, we are on page 21 of 31. The circuit court's finding and the Court of Appeals affirmation, contrary to its prior finding that the Veli CD could serve to show Bobby's motive if Mr. Avery supplied direct connection evidence, that Mr. Avery has not established the motive. Anytime you see me do this, for people that don't know, it's because something's in quotes. So establish the motive element of Denny is contrary to Wisconsin law. Wisconsin cases that discuss the motive element of a Denny analysis show that the standard, so now this is going over other cases for Denny. I'm not reading any of that. This is another case. Somebody was stabbed. So, all right. Mr. Avery, in his motion, presented far more evidence that is even required to suggest that a third party actually committed the crime. The lower court's failure to consider the Denny prongs in the aggregate and their erroneous imposition of a burden of substantial certainty on Mr. Avery's motive evidence to prove beyond a reasonable doubt that Bobby conducted each search is reversible error. Bobby is the only person who has been identified as having taken unlawful possession, and then it's got in brackets, theft, of the victim's vehicle and had an abundance of violent porn of young women on the computer in his room, for which he has been described as the primary user. Combined with these damning facts is his role as the primary eyewitness against Mr. Avery at his trial. Next section is titled, Mr. Avery has offered even further evidence of motive with the Sawinski evidence because it shows that Bobby had possession of Ms. Halbach's vehicle. If not sexual, Mr. Avery even offered another potential motive for Bobby. After obtaining the Sawinski evidence that Bobby was in possession of Ms. Halbach's vehicle, a vehicle that he unlawfully obtained, it is only logical to conclude that Bobby's motive could have been theft. The Court of Appeal contended that the theft motive was not properly pled in Mr. Avery's motion, but it was by the submission of an eyewitness account by Sawinski that he saw Bobby in possession of Ms. Halbach's vehicle after her disappearance. Sawinski supplied sufficient detail that this was a theft. All right, let me scroll because I'm going off script again. Something else Stephen told me. Bobby Dassey was regularly stealing parts off of cars in the pit and selling them. This is how the family makes their money, is having this junkyard and selling these car parts. But Bobby would steal stuff off the cars and sell them. And Bobby was also dealing drugs out of the pit. Out in that pit, Carla, Stephen's niece, who calls herself the spokesperson, Carla told me back when Carla and I were friends that when she grew up at the salvage yard, she would regularly have parties out in the pit because the families couldn't see him back there, and there was access to get into the pit, into where all the cars were parked through the quarry. Now, when I went to Avery Salvage Yard for the first time in January of 2016, and we walked through the salvage yard. We also drove through the quarry. At that time, there was a road that you could go directly into the salvage yard. Since Making a Murder became the big sensation and everything that it is, there is now a berm to make it harder to get into the salvage yard from the back way, but people still could. But Bobby was not a great kid, and Stephen actually got into an argument with his sister Barb about Bobby because Stephen, being 2 years out of serving for a crime he didn't commit, and is now his wrongful conviction case was just starting up and doing depositions. He doesn't want to do anything remotely that, no, remember, he's still a felon due to the prior case with his cousin. So he doesn't want Bobby stealing shit and selling drugs. And so he got into an argument with Barb, telling her that she needs to do something about her boys, and that her boys were never going to amount to anything. So actually, Stephen had invited Brendan over for a bonfire, and Barb didn't want Brendan to go. There was a prior bonfire that she didn't let him go to because she was now mad because Stephen had yelled at Barb about Bobby being such a loser. So there you go on that. All right. Next section is Mr. Avery's evidence satisfies the, this is underlined, direct connection element. The Court of Appeals, in an argument that strains credulity, Jeff, how do you say that? Credulity. He's not listening to me downstairs. I don't know how to say that word. Credulity. Claimed the RAV4 that Sawinski witnessed was not necessarily Ms. Halbach's vehicle in order to dismiss Mr. Avery's direct connection evidence. Specifically, the Court of Appeals disputed that the RAV4 belongs to Ms. Halbach, finding, quote, the Sawinski affidavit, however, only stated that Sawinski saw Bobby and another individual pushing a blue-colored RAV on November 5, 2005, unquote. Apparently, the appellate court believes that Sawinski was required to obtain the VIN number of the RAV4 that he observed to rule out the completely improbable scenario of Bobby pushing another blue-colored RAV4 onto the Avery property on November 5, 2005 in the early morning hours. Let me pause right here to go. I am not a big thing on the blue and the green RAV4, that there's two different ones and one's blue and one's green. Her car is the color of her car is teal, is the official color of it. And I have had a car that was, I believe, did they call it Patriot Blue? I can't remember. A Ford. Of what color blue it was. And in most lights, my car looked black, but it was actually a blue car. And to prove the point even more is on one of my field trips to Manitowoc, and when I was busted for, as Earl Avery calls it, trespassing, when I walked through the Redont deer camp. When I received my ticket for trespassing, Manitowoc Sheriff's Department labeled my car as black when my car is blue. So I don't think there are two different RAV4. I don't care if somebody said it was blue or somebody said it was green. They're both, it's Teresa's car, whether or not you thought it was blue or green, because it's teal. All right. Unlike the Court of Appeals, the Circuit Court correctly acknowledged, quote, the Sawinski affidavit, taken as true for the purpose of this motion, directly links Bobby to the possession of the victim's vehicle, unquote. The Court of Appeals rationale is incorrect, as it did not take Mr. Avery's pleadings to be true. And now it's talking about another case. Don't care. Applying this common sense approach here, the Sawinski evidence provides the direct connection, and then in brackets, that is Bobby being witnessed in possession of Ms. Halbach's vehicle, to Bobby having committed the murder of Ms. Halbach and planting the evidence to frame Mr. Avery. There's a footnote that says Mr. Avery realizes that this case existed 2 months. Oh, talking about the other case. Don't care. The RAV4 is a material piece of evidence in the crime. And now talking about another case. I really hate to get any consideration. To get a case back into court, you have to cite another case that's similar to yours. Stupid. I don't like that. All right, still talking about another case. Here, the circuit court admitted that Mr. Avery established Bobby's possession of the RAV4, but it created other explanations other than acknowledging that Bobby had possession of the RAV4 sometime following the murder of Ms. Halbach. Bobby is now connected to material evidence in the Teresa Halbach murder case. So again, wouldn't that get you back into court? Shouldn't that get you back into court? If the court is going to say, yep, Bobby had the car on this date, and a defense has been, oh, he could have been moving that for Stephen then. But still, he was your star witness against Stephen. So why wouldn't this impeach his testimony? And let's go to court again. The Denny test only requires an inference that Bobby is directly connected to the murder of Ms. Halbach, nothing more. By having possession of Ms. Halbach's vehicle after her disappearance, the inference can certainly be made. The Sawinski evidence is being offered as evidence of the missing piece, the direct connection between Bobby and Ms. Halbach's murder. Contrary to the lower court's positions, Mr. Avery does not need to prove Bobby's guilt of the murder beyond a reasonable doubt. Next section is titled Mr. Avery, and we're on page 24 of 31. Mr. Avery showed that there is a reasonable probability that presenting Mr. Avery's newly discovered evidence undermines confidence in the outcome of Mr. Avery's trial. Oh my God, it's 7 o'clock here now. Mr. Avery has adequately shown how his newly discovered evidence would have changed the outcome of his trial. The new evidence would have allowed the defense to impeach Bobby's trial testimony. During his closing argument, Prosecutor Kratz, sweat, emphasized the importance of Bobby's testimony and vouched for his credibility. Quote, "We talked more about the timeline and we heard from Bobby Dassey, again, in the same kind of a position to be his credibility to be weighed by you, but is an eyewitness. Again," and now this is bold, "an eyewitness without any bias." Bobby's got a ton of bias. Anyways, it is and this is intentionally, he didn't say an individual, he said a individual that deserves to be given a lot of credit, because sometime between 2:30 and 2:45, he sees Teresa Halbach. He sees her taking photographs. He sees her finishing the photo shoot. And he sees her walking up towards Uncle Steve's trailer. Nobody calls him Uncle Steve, by the way. They call everybody by their first names. Bobby would no longer, that's unquote. Bobby would no longer be the unbiased witness described by Prosecutor Kratz. Further, the forensic evidence would have been viewed as planted, or at the very least tainted, he is a taint, by being in the hands of a third party. With the new evidence, the defense could have argued Mr. Avery returned to his trailer. Ms. Halbach left the property in her vehicle, and Bobby followed her, got her to pull over, and assaulted and murdered her at some point. He planted the RAV4 on the Avery property and proceeded to remove and plant the electronic devices, the key, the bones, her clothing, her DNA on the bullet, and Avery's blood. The Sawinski evidence, when viewed in the aggregate, including all the false statements made by Jeff to law enforcement and at trial, would have provided a reasonable probability of a different outcome at a trial. Next section is titled, Whether the Court of Appeals improperly affirmed the Circuit Court's decision to deny Mr. Avery an evidentiary hearing. Standard of review. Whether a defendant's post-conviction motion alleges sufficient facts to entitle the defendant to a hearing for the first relief requested is a mixed standard of review. First, the reviewing court determines whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief. This is a question of law that is reviewed de novo. If the motion raises such facts, the circuit court must hold an evidentiary hearing. However, if the motion does not raise facts sufficient to entitle the movant to relief, or presents only conclusory allegations, or if the record conclusively demonstrates that the defendant is not entitled to relief, the circuit court has the discretion to grant or deny a hearing. The reviewing court reviews a circuit court's discretionary decisions under the differential erroneous exercise of discretion standard. Now it's talking about another case. Next section's titled, Mr. Avery alleges sufficient facts in his third motion, entitling him to a hearing. However, the lower courts disputed those facts instead of taking them to be true. Talking about other cases. Both the Circuit Court and Court of Appeals improperly attempted to weigh Mr. Avery's facts with speculative theories unsupported by the record, rather than accepting his facts as true and determining whether they were sufficiently pled to warrant an evidentiary hearing. The Court of Appeals offered the theory that Sawinski saw a different RAV4 and not Ms. Halbach's RAV4, as he claimed. Both courts failed to conduct any analysis of whether Mr. Avery pled sufficient facts to warrant an evidentiary hearing on his newly discovered evidence. Instead, the lower courts weighed Mr. Avery's evidence as if it had already been presented during an evidentiary hearing. When the lower court's analysis begins to weigh the evidence, quote or bracket, it inevitably misstates, and the uncontradicted facts a petitioner asserts are not taken as true, the need for an evidentiary hearing becomes apparent. In Mr. Avery's case, each court has assumed as true a different theory or a different part of the theory than the other. No court has looked at all of the evidence cumulatively to determine the likely impact on the defense, on the prosecution's case, or on the jury's verdict. An evidentiary hearing is nothing more than an intermediate step toward the objective of being granted a new trial. It is not an end in itself. The evidentiary hearing is a forum to prove allegations in a motion for post-conviction relief. Mr. Avery's motion for post-conviction relief states what he is set to prove if he were granted an evidentiary hearing. An evidentiary hearing would provide Mr. Avery with the opportunity to prove his pleaded claims that he is entitled to a new trial. If Mr. Avery's motion contained all the proof necessary to show that he was entitled to a new trial, he would not need an evidentiary hearing. Because Mr. Avery has alleged sufficient facts in his motive that, if true, would entitle him to relief, yet the lower courts keep denying him the opportunity for an evidentiary hearing, Mr. Avery asks this court to revisit what is required for an evidentiary hearing. Conclusion. We're in the home stretch here. Petitioner Stephen Avery's case raises 3 critical issues on which this court's guidance is needed. First, Mr. Avery presents this court with an opportunity to correct the lower court's misinterpretations of law in what is required to bring forth newly discovered evidence. Second, Mr. Avery presents this court with an opportunity to return to this issue of the extent of motive, opportunity, and direct connection that is necessary to satisfy the Denny third-party suspect test for admissibility. Third, Mr. Avery presents this court with an opportunity to correct the lower court's misinterpretations of the pleading standard to obtain an evidentiary hearing on Mr. Avery's claims. Fourth, Mr. Avery presents this court with an opportunity to grant him a new trial in the interest of justice. Petitioner Stephen Avery respectfully asks this court to grant him leave to appeal the issues raised herein. Respectfully submitted by Kathleen. And scrolling through the following pages to see if there's anything on here that needs to be read. No. So that is everything. Now, again, not the pretend lawyer. I do not know how long the Wisconsin Supreme Court has to respond. They may not have no limit. So it could be forever until we hear anything. Um, I don't recall. I will try to reach out to Kathleen and see if she will let me know how long until we could hear something. When there is something, well, actually, I think the state gets to file a response to this, right? Is that how it's going to work? Um, but as soon as there is something filed and we're able to get it and I can go live, I will go live and read it to you. I do not necessarily see things in a timely manner. Thank you to the person who sent me this over the weekend because, like I said earlier, I did not know this was even filed on Friday. So please, if you see that there's a response by the state or a response by the court, please send it to us. You can message it to Stephen Avery Project here on Facebook. You can email it to official Stephen Avery Project at gmail.com or justicewithjax at gmail.com. And then we will have it here for you as soon as we can. I think that is everything since I've been on here for 2 hours and it's after 7 o'clock already and I am starving and I would like dinner and I'm sure my husband would like dinner. Thank you everyone who joined us live today. And now remember, I did this on Monday, February 10th. So for those of you who watch it recorded, I cannot answer your questions as you post in here. Another plug for my book. You can get Wrongfully Abused by Jax West on Amazon. So I am out. As always, investigation continues.